Hey guys, so I've been working in patent since I was in middle school. My dad was a patent attorney. I am a patent attorney. I've been a patent attorney for over 10 years. I've worked in patents as a patent agent since 2009. So I passed my patent bar exam when I was only 21 years old, straight out of college, and that is very rare to see. Now, today we're going to talk about Nintendo's new patent. This is a breakdown of why it would be important, how it actually got granted, and so on. So, Nintendo and the Pokemon Company have been recently granted. So, this is different. Granted is different from applied. Many times you will see patent pending, and that is completely useless, in my opinion, as a patent attorney, because patent pending doesn't mean you can sue someone because you don't have the patent. This has been granted. This is not patent pending. This is patent granted to cover certain gameplay mechanics which are familiar to fans of Pokemon style or creature collecting games. Among the key ones, patent number 12,403,397 covers a summoning a character and letting it fight another mechanic. This includes throwing a ball type object to capture or deploy a creature into battle. This patent application was filed in March 2023. It was granted, becoming a full patent in September 2nd, 2025 by the USPTO, apparently without objection. So in the patent process, people like, let's say, Atlas, they have Shin Megami, very similar mechanics where you summon a character, it battles Digimon, Bandai with Digimon and so on. You can Power World. You can think of numerous Final Fantasy where you summon a character. It's a summoner type character, and it does battle for you. Mega Man. I remember playing Mega Man where it was like network Mega Man, and you would summon these characters using these chips, and they would do a effect on the field. So, without objection means none of these companies, Atlas, Power World, whoever makes that game, objected to it. And many times because they simply are not aware of any of these patents. Patent number 12,409,387 related to the smooth switching of riding objects. This is when you're on the Latios and you're flying in the Mega Latios, you're flying, you're on your Lapras, you're swimming. That is mechanics where a player mounts, you are on Meridon and you're moving around. Mounts rides a creature or object, possibly flying or otherwise through moving through terrain, switching smoothly between riding states. These were again granted, they were filed, and most importantly, granted in parallel with Nintendo Pokemon's lawsuit against Pocket Pair, which is actually the makers of Power World. For alleged infringement of certain game mechanics, some changes have already been made to Power World following this lawsuit. So in 2023, they wanted to sue Power World. They realized that, hey, we probably need to get these patents. That way, the litigation will be a lot easier for us. And they got the patents granted. Now, why is this concerning so many people? The patents cover mechanics that are very widely used across many games, not just Pokemon. Some concerns include broadness. The mechanics sound very fundamental. Summoning a character creature to battle another, riding objects, creatures, etc., which many games, even ones predating these patents, already feature. That raises questions about how enforceable or valid such patents really are, especially with respect to prior art. So games even earlier than Pokemon have very similar mechanics. Chilling effect on indie small developers. If such patents are upheld and enforced, smaller studios might get sued or threatened for mechanics they assume are generic or standard. This risk might cause studios to self-censor or alter designs even if they believe they are not infringing, and this is especially impactful for smaller studios who don't have lawyers to defend themselves, right? A lawsuit would basically be the end of that studio. Patent system criticism. Some IP lawyers are arguing that these patents reflect a failure of the U.S. Patent Office evaluation process. The concerns include that the grants might have ignored or insufficiently weighed prior art, or that claims are overly abstract. So let me explain what happens. So a patent examiner gets assigned to, well, I guess there's two patents, but for example, one of the two patents, maybe both of them, but it could be two different examiners. It could be the same examiner, but a patent examiner gets assigned. The patent examiner's goal is to not grant you the patent. So you're going to have to prove to the patent examiner that this is not infringing on prior art. It is the patent examiner's job to do due diligence, do something called prior art search, and take the whatever else exists out there and tell Nintendo, hey, I found all these other games and they have very similar mechanics as what you're trying to patent. I don't think we can patent it. And then it's up to Nintendo to respond. In this case, many IP attorneys are saying that the patent examiner is not. Now, again, trademark attorneys, they don't really know what's going on here. Copyright attorneys, they don't know. This is for patents. Patent attorneys are a level and a cut above both trademark and copyright. Patent attorneys can do trademark and copyrights if they have the time. But many trademark and copyright attorneys who are not barred by the USPTO cannot do patents. And one of the more interesting things about the law is patents is one of the only areas where you would have to know that you want to do patents even in high school. So before you pick a major, your major has to be science or hard science. So psychology is not considered a hard science. So no to psychology majors. Hard science would be biology, chemistry, physics. It also can be engineering or some math-related major. Then they will allow you to sit for the patent bar exam, where about 50% of people fail. Sometimes a little bit more, sometimes a little less. It's 50%. So this is pretty interesting. Now, obviously, they're targeting Palworld. So Palworld has already made changes in its gameplay in response to legal patent pressures. For example, the method of summoning its pals by throwing spears akin to Pokeballs was changed. They removed aiming, throwing in favor of creatures simply appearing when summoned. So there's not the Pokeball element of it. Nintendo is not limited to just suing Palworld. The patents potentially open the door to legal action or threats against other developers whose games have similar mechanics. And let's be honest, summoning a creature to battle another creature, that is a very common mechanic used across multiple games. Some media expert commentary is warning that these patents could deter new games in the monster collection genre. Yeah, actually, no, I now think mobile games, gacha games, right? Where you're trying to summon these characters and so on. I mean, that kind of would be. There are many gacha games with these mechanics are required developers to do more legal research, risk assessment before including certain features. I would love to represent someone to sue. Now, obviously, Palworld, right? They already have their legal team. It would be interesting if you are an indie developer and Nintendo sues you, reach out to me because I could probably do it pro bono for you. That's how much interest. Pro bono means I'm not going to charge you money. That's basically an easy way to say I'm not going to charge you. You might have to pay the fees and so on, but I won't charge you for my time. And I do have a pretty good record in patents, having done this for so long and having grown up in a household. I used to get paid $1 every time I could talk about patent. For every dinner conversation with my dad, again, he's a patent attorney, I used to get paid $1 for every dinner conversation if we were able to talk about patents at the time. So I used that money to save, ironically, for Pokemon and Pokemon cards. Pokemon games. So the validity, developers or others could challenge these patents on grounds of prior art if earlier games clearly show the same mechanic. That can invalidate or narrow the scope of the patent. Claims that are overly abstract might also be challenged under U.S. law, specifically Section 101, which deals with what is eligible to be patent protected. restricting or changing game design. If patents are upheld, designers might have to adapt such mechanics to avoid infringement. Examples of this would be different summoning or riding mechanics, or different visuals or workflow. So this would be a lot of leverage, because remember, these are patents that are granted. This is not patent pending where there's pie in the sky, right? I could have a patent pending for water for like a day before they like read what I'm trying to do and then reject me. But a lot of patents that are patent pending aren't ever going to be approved. No, this is actually approved. So this is a very different arena that we are finding ourselves in. We are actually in a approved patent, which means they can go on a suing spree if they want to. So the threat of lawsuits might stifle innovation or experimental, especially at the indie game level. So again, if you are an indie game developer and Nintendo comes knocking on the door, I don't think you can find a better lawyer for free. For free. Again, that's a big caveat, right? Than me in the patent field, having practiced in patent law. I worked for, when I was 18, I interned in China and then in the US, in New York City, for the largest Chinese IP law firm. Many of you go, oh, what IP do you have in China? Well, the funny thing is, in China, if you are the company I worked with was Paramount Pictures. If you are Paramount Pictures, trust me, China does care about you. If you're a big American corporation that can spend a lot of money, China does care about you to the extent that whatever you want. I'm not going to go into too much details, but they do offer at that time. About 18, so I'm 38 now. That's 20 years ago. Yeah, 20 years of doing patents. Crazy. Anyway, that is it. It's long enough video. If you guys want me to cover this more, I can, but it's kind of boring stuff. It's exciting for me, but it will be very boring for you, because it's a lot of patent. If you love patents, you're going to nerd out, but most of you are not going to nerd out. Anyway, bye guys.